The holder of such a public office cannot be held to account by being cross-examined after she herself has given a witness statement, then, my lords, with the greatest respect, we would be posing grave dangers to the Republic. Because the holders of important offices can shield themselves from accountability by saying in every case that we will not allow ourselves to be cross-examined and nobody can do anything about it. And what I submitted earlier, and which ties into this point that I'm making, is that if it were not for the fact that she is the representative who has sworn a witness statement on behalf of the first respondent, it would be open to us to ask the court for a subpoena to have her testify. So, my lords, we respectfully submit that in the circumstances that we are faced with here, with this particular holder of this particularly singular office that is supposed to make a determination that reflects the sovereign will of the voters of Ghana in an election, which is what democracy is all about. It is our respectful submission that that constitutional obligation cannot be set aside by subsidiary legislation or by reliance on subsidiary legislation. It cannot. Every legislation that we've talked about, CI 87, CI 47, and I mean, none of that can set aside the sacred public duty of this chairperson and the need to account for that public duty where the forum demands it. And my lords, this is a forum that demands it. My lords, reference has been made by my learned friend to the case of armor versus hydrofoam. And that was indeed a Supreme Court decision in 2012. The decision read by Justice Baining and a court that comprised various justices, including your Lordship, the Chief Justice. Now, my Lord, that case has absolutely no application to the circumstances that we are dealing with. Because in that case, what happened was that the parties had agreed that instead of testifying by themselves, they would both rely on the testimony of an expert, a surveyor. And on appeal, the point was raised that the plaintiff himself ought to have testified and not rely on the evidence of the expert. Within that context, the parties had agreed that we're going to rely on an expert because this is a matter on which an expert can resolve the issue between us. We don't need to be sort of testifying and, we are not the expert. We'll rely on an expert. The parties had agreed that. Then they go to court and one party is more or less arguing that because the plaintiff did not testify, it should be held against him. My lords, of course, rejected that argument, and my lords made it clear